My name is Michael Cover, and Dave Owen, who you also see on your screen, we're the kind of joint moderators of this and have been some time since we lost, sadly, the other David Richbell. A couple of bits of housekeeping. First, this is being recorded, and the recording will be made available later. We've got, I think, 3 poll questions, which we will feed in at various different stages, which are hopefully relevant to the topic. We'll talk about our next meeting at the end, and also the possibility of a lunch when we're all allowed to do that, probably around Christmas. So apologies that our original speakers had to drop out for very important personal reasons, but we thought it'd be useful and topical to have a conversation about the Civil Justice Council report on compulsory ADR, and also the comments of Jeffrey Voss thereon. So in accordance with our usual practice, Dave, would you like to invite some people who are attending for the first time to very briefly introduce themselves? We're going to do about 10 of those. So if those of you who are attending for the first time, or as David's got a list, and then Martin can find you and unmute you, or you can unmute yourself. So over to you, Dave.
Thanks, Michael. Hello, everybody. Morning, afternoon, whatever time it is with you. I've got a little list. So if you're already on, could I please invite Sarah Briley? I think that's the correct pronunciation. To say
morning.
Hello. Would you like to say hello and what your interest is in mediation, if any?
Hi, I'm Sarah Briley. I work for Family Mediation Cymru. I'm a BBC, and I've been working as a family mediator since 2008, I think. Yeah, so that's me.
Okay, thanks very much. Liz Brown, if you're there, please. Are you there, Liz? Okay, I may come back to you. Will Chalmers, are you there, Will?
Hi, Dave. Yeah, thank you.
Hi.
Actually, I'm the first one to attend, so I got my colleague Lisa here.
Yeah.
So
okay,
just
I was
nice to come to say hello.
Later, but you can both have a joint.
So say hello.
Hi.
Good morning, everyone. Good morning, everyone.
And anything you want to say?
Oh, sorry. Yes, I just saw you muting me. Nobody will flow quite a bit. Yes. So Mediators Network represent lots of mediators around the country. We do lots of activities and things. So it's good to sort of always meet new faces and see people and get together. And this is a great opportunity to sort of say hello. So hello for me and hello for Lisa.
Lisa, do you want to add anything?
No, well, this is my first time, so excited to be on board. Starting with Will officially next week, so I'm just looking forward to working with him. It's going to be exciting.
Okay, great. Thanks very much for that. Sarah Edwards, if you're there, please, Sarah. No. Lorenzo Fioriti, if that's the correct pronunciation. No.
Not present.
Not present, okay. Mohammed Islam, if you're there, please. No. Mumtaz King, if you're there, please. No. Emma O'Hanlon. Emma, are you there? I'm not doing very well this morning. No. Is it Mary Pung? I'm not quite sure how you pronounce that. Mary? No. Alvin Sim from Singapore, if you're there. Alvin, no. Lisa Weston. No. Oh, as there are very few people who've actually seem to be on already. If you're a first timer and you would like to say hello, please just unmute yourself and carry on.
Okay, well, I can say hello. So I don't know if I suddenly popped up on the screen. So I'm Christen Forster. I've only just started to kind of get involved in mediation work. Historically, I've been involved in kind of the development of people psychologically. Some of that was with has been with victims of abuse surviving and so on. And as such, I found myself sometimes drawn into often as an advocate. And so I'm very much kind of in the exploratory side of coming into mediation. But it's a delight to be here. So thank you for the opportunity.
Thanks, Chris. And whose bridge is that behind you?
Yeah, so I'm not really in San Francisco. I'm just hiding the fact that I have a rather scruffy wall behind me.
Okay.
In a small office.
All right. Anybody else?
Yes, Dave.
Oh, hi, Dave.
Oh, sorry.
Oh, go ahead.
Shall
Go ahead,
I leap in? Hi. I'm not exactly a new member. I have attended a couple of these many years ago. I retired from legal practice at the end of April, and I'm now looking to develop my mediation practice. And so look forward to attending many more of these meetings. Hello, Michael. Hope you're well.
Hello.
Thank you. Who was just about to say something?
Me, Dave. Hi.
Yeah, hi.
Right. I'm Chuck Kanafi. I'm a commercial mediator working out of Berlin. I was originally trained and began practice in Israel. And in the September meeting, I'm going to be talking about the new Israeli mandatory mediation regs with you fine people.
Thanks very much. Anybody else who'd like to?
Yeah, I could go.
Hi,
everybody. Yeah. I'm Yvette Fidler. I'm a family mediator working in Leeds for Apex Family Law and Direct Mediation Services. I've been mediating since 2017.
Right, thank you. Any more?
Morning, everyone. Hi, I'm Katie Jolly. I'm based in Hertfordshire. I'm a family mediator with background in child protection. I've been mediating for about 7 years. I've earlier this year completed my workplace training and accreditation, so now looking to expand into workplace. Nice to meet you all, and always lovely to see other fellow mediators.
Thank you. I think we've got time for a couple more. Anybody else?
Hi, I'm Rajinder. I'm Rajinder Rai. I'm a solicitor and mediator from Kent. I practice in dispute resolution of various types of legal disputes. I've been qualified for over 20 years, and I became accredited as a civil and commercial mediator and a workplace disputes mediator about a year ago. So looking forward to growing and doing more mediations in the future, and considering the rollout of compulsory mediation, which seems to be occurring right now. So looking forward to hearing what we're going to say about that.
Good.
There's a lady called Sue who's been trying to get in.
I was just going to say, yes, Sue's the last to say.
Thank you. I'm Sue Nelson. I work for Essex Mediation, and we've been operating for 20 years or so in Essex and in surrounding areas. And it's very nice to see so many people here and to be part of it. Thank you for inviting me.
Thanks so much.
Okay, thank you, Dave.
To you, Michael.
Thank you. Well, good morning again, everybody. I'm not going to ramble on with a lot of opening remarks. There's nothing worse than going to a meeting, whether it's face-to-face or by Zoom, and looking at one or more talking heads. But I thought I'd throw out a couple of thoughts. For those of you who read the Civil Justice Report, you may have noticed they seem to have ignored or not noticed or never known that a form of ADR, in other words, adjudication, has been mandatory in construction for really quite a long time. I think the Act came into force in 1998. I'm not sure that I think there's other places they could have looked at, like Ireland. And the question I ask myself is, do we really understand the nature of ADR? And actually that it's a big business for UK PLC. And does the government and other people recognise that conflict does great damage to the social and economic framework of the UK. And perhaps finally, as a first thought, is it fair?
We've lost you, Michael, I think.
Michael, you've frozen.
Got some other thoughts which I'll share as we go through, but would somebody like to pick this up? Who'd like to go first?
Michael, perhaps you repeat what you said. You blanked at, is it fair? It's
I'm sorry.
We can't hear what you said.
No, sorry, that's right. Sorry. I'm in the Isle of Wight, and touch with the internet connection here is pretty good, but it just wobbled then for a minute.
Okay.
Yeah, is it really fair or right that the English common law should be developed at the expense of the parties in disputes? That's what I was saying. So perhaps somebody'd like to start on the whole subject of what is ADR, should it be compulsory, and so on. So who wants to go first?
Could we use the raise hand function, please, if you want to contribute? Who's first?
I can't see.
Hugh
Elder, I beg your pardon, Hugh Elder would like to speak.
Thank you. Only because nobody else wanted to seem to want to. I've always been rather against making mediation compulsory. I know that mediation is only one type of ADR, and I think Michael Cover's made a very good point about adjudication not really being covered by this report. Because I always felt that if parties were forced to mediate, that could be counterproductive. But I'm quite persuaded by sections in the report which liken a sanction for not mediating to those of not complying with disclosure orders or filing particulars. And I'm also find it very interesting that the authors who have mediated say that parties who are reluctant to mediate very often come round to the idea when they see it working in practice. And I think that leads on to the main objective of the mediation profession, if you can call it that, which is to spread the word about mediation, because there's still massive ignorance among the public and also among some lawyers, it has to be said, of what mediation entails and the advantages that it can bring. Thank you.
Thank you, Hugh. Now, who else got their hand up? Okay, that's Will.
Hi, thanks, Michael. Very interesting points, and I think even Dave and I had this discussion a little while ago about, compelling people to mediate. I've been in contact with a couple of people around the world in recent weeks talking about this very subject, actually, and a professor in Turkey, as one example. Turkey is compulsory to go through mediation, and he said it's not foolproof. There are some gaps, but it by and large works very well. Because it shifts the mindset to people going through a process to engage in something. At the moment, obviously, you have to get everyone around the table. That's the biggest hurdle, isn't it, at the moment, getting everyone around the table. And I think Dave and I were talking a little while ago about, when you get somebody to the table, even at that point, parties' minds can shift, and there still can be a good level of interaction. And therefore, proper, acting in good faith, to come to a resolution. But so the act of compulsion is not necessarily the problem. It's I think, as he was touching on as well, it's the education and the understanding of what mediation is, and yes, its advantages, of course, but what the results can be for, I think, Michael, you said this in terms of the UK PLC, what businesses will get as a result, what smaller companies, what families will receive beneficially wise as a result of going through this sort of process. Incidentally, Michael, just to sort of say that Turkey the professor was explaining that now there's such a demand for mediation services. The problem has now shifted from the courts not having enough capacity to not being actually physically enough mediators to do the job. So that may be something to talk about as well.
Okay, well that's extremely interesting. Who else has got their hand up?
If only, Will.
So Julian Whiting, yes.
Yeah, Christen will be able to articulate the bits that I miss out, but I just wanted to make the point, and having noticed a lot of stuff with big institutions, and then you've got, it's like David and Goliath. I think if any parties are going to get involved, they need to be absolutely clear right from the outset about the emotional intelligence that's missing, I think, in a lot of these cases. And I think it's quite a big thing for anybody to dare to even go into a room. It's like a courtroom, Michael, which you're probably used to over the years, and many others on this platform. But I think it really requires a bit more emotional intelligence before anybody decides to go into this mediation stuff. And I think everybody would benefit more, because it's not all about the money. It's about being heard and moving on effectively. So I just wanted to throw that in for what it's worth.
Yeah, Anthony Fincham's got his hand up next, so we'll yeah, hang on a minute. I was just going to make an observation. I was talking to my colleague Sheila Bates about this yesterday, and how there almost needs to be a conversation
okay,
about.
Don't worry. Are you looking for the link?
Yeah, hang on, Dave. You're on.
Yeah.
Can you mute, Dave? Can you mute? That's it. Yeah, there almost needs to be a conversation about the conversation. Do you see what I mean? And there needs to be a lot more ground preparation. There certainly needs to be a lot more education, because there's far too many people. You know, I've got an arbitration where the litigation has been stayed for reference to ADR. So there was an arbitration clause in the agreement, actually. So that's what we're doing. But there's a lot of confusion, but there's a lot of terms that are bandied about, even by people who really ought to know better. Anthony, do you want to go next? Good morning.
Michael, yes, good morning, everybody. I mean, I have always been against compulsion in mediation, but I think for principled more than pragmatic reasons. And you might have noticed in the report a comment by Lord Phillips when he was LCJ in a speech, when he said it's of the essence of mediation that the parties are prepared to consider foregoing their strict legal rights. And I just don't see why, take a terribly simple example, somebody owes me £1,000, they come up with all kind of rubbish and obfuscation as to why they shouldn't pay. You know, why should I be forced to undergo some process outside the recovery of that amount in which it's implicit that I will give up my right to be paid? So I think it's wrong in principle. But Michael, could I just add a question, although this might be on your poll, that Halsey comes under attack in the report, really, and I've heard this from many people, but does anybody have experience of, or so much experience of adverse cost orders? I've never myself come across a cost order for failure to mediate, and that's really the only sanction at the moment. And does that happen in practice? I've asked around, I'm not sure I've ever spoken to anybody who has suffered or applied for a cost order flowing from a failure to mediate. So I don't know whether you'd like to throw that in at some point, but it'd be interesting to know whether these cost orders are really made on any sort of scale, which is the only way of sort of compelling or encouraging mediation at the moment.
Okay, well, that's very useful thought. Anthony and I are colleagues in our DB chambers, just so everybody knows. I think Louise Clark, you had your hand up. It's better if you unmute Louise.
Thank
we
you.
used to be colleagues as well, didn't we, Louise?
We did indeed in those halcyon days.
Yeah.
I just wanted to say that I thought that the report was interesting in the way that it highlighted what the existing compulsory processes in various jurisdictions, in the family and employment jurisdictions, for example, and the family lawyers here will know that better than I. Financial dispute hearings are mandatory, as I understand it, and they seem to take place without a problem. And there are also directions that the court imposes, and since the days of Halsey in 2004, there's been increasing judicial encouragement to mediate, including the courts making stays for the parties to seek to resolve their differences, and latterly, I think, directions where the parties are required to consider ADR at each stage of the process, and if they refuse to engage in any sort of ADR process, they must justify their position. And to answer Anthony, yes, there have in recent years been a number of cases where cost penalties have been imposed, and parties have succeeded in being awarded indemnity costs where parties have failed to agree to mediate, justifying their decision on the basis that they think they have a strong case. So I think the courts have been moving increasingly towards the position that we're now in, and I see it as an incremental movement, perhaps. And I think the report also makes it quite clear that whilst it's not a breach of human rights to impose mediation, there always has to be the possibility of the parties having resort to the legal process if mediation doesn't work. I think that's the safeguard.
Yeah, I think it's interesting, Louise, thank you. Just on Anthony's point, of course, we all generally know that even if you've got a slam dunk case in the real world, you've actually only got a 75% case. So I think that would be part of my answer to your point about claiming £1,000 back, because if you get a judge who's got out of bed on the wrong side in the morning, and we've all encountered that in our time, then that it's not 100% certain that you're going to recover, even where you think you've got a 100% case. I mean, that would be my thought. I don't know whether you want to come back on that, Anthony. There's always risk. There's always risk.
I totally accept your 75% point having regard to the judge, and no litigation is entirely predictable. But my point is a slightly different one, that, you know, I should be entitled to say, I wish to take my chance with the judge. I know I'm owed £1,000. I feel I should have an open door to justice. If I lose, that's bad luck, rather than engaging in a process that's bound to incur some cost and delay, where, as Lord Philip said, it's of the essence that I accept that I will forego my strict legal rights. So that's what I'd say to that. But I'm, as I say, it's principled rather than a pragmatic view of the matter.
Yeah, I think that's interesting. Just before I call on the next one, I suspect quite a lot of us are familiar with Frank Sanders and his multi-door courthouse, which is practiced in Nigeria quite a lot. This is a courthouse that has 3 doors, one for litigation, one for arbitration, and one for mediation. So perhaps there's something much wider than just compulsory ADR at stake here. Who would like to make, who's got their hand up now? Let's see who we got. Martin, can you see somebody with their hand up?
Oh, nobody at the moment.
Okay, any don't be shy. Anybody got their hand up? Okay, sorry.
I have Michael.
Who's that?
Stephen Walker.
Oh, hello, Stephen. Yeah, good morning. Go ahead.
I was just going to ask if you were with us.
You're being suspiciously quiet, Stephen.
Yes.
Good morning.
I wanted to see the lie of the land. The first thing is that I was encouraged by the report, but I confess to being discouraged by this discussion. There's an enormous sense of déjà vu. We've been talking about why mediation hasn't been more successful, why there aren't more people doing it for years. And frankly, to start a discussion like this with, do we need to define ADR, suggests that we're engaging in too much navel gazing and not enough marketing. Over to the big objection to mediation is often there is no outcome. And the more that people can feel that it's worth their while doing this, and one way of doing it is we're all in it together. We've got to do this. I think compulsory mediation is desirable. I don't agree with Anthony Fincham at all. I think it's also desirable from the point of view of marketing. More people have to do it, the more people they'll get used to it. Also, I think that it's right that there's quite a lot of hidden compulsory mediation. Lots of contracts now contain, as you know, waterfall dispute resolution clauses, and they require people to try mediation before even going to arbitration or litigation, and the courts enforce them. So you have contractual compulsion. People do turn up, oh, I'm only here because I've got to be here, and guess what? They get caught up in the spirit of the day, they get caught up in the momentum, they settle their problem. I also think it's wrong of Lord Phillips to be constantly quoted about his speech in Delhi or wherever it was about foregoing legal rights. It's a trade-off. You're trying to sort out a dispute. One way of doing it is by going to lawyers. Another way of doing it is by discussing it with the people you're in dispute with and finding out, using your own experience and skill, a solution rather than having one imposed on you.
Thank you. Thank you, Stephen. Actually, I mean, I've been banging on for some time that actually we should stop talking about justice and should start talking about resolution. Perhaps that's something you were hinting at towards the end of your remarks. Now, next, I think the program on Russia Today is called Crosstalk. There's an American guy who does it. So we got Michelle. Go ahead, Michelle, wherever you are.
Hello.
Hello, Michelle. Yeah, there you are. Good morning.
Good morning. I've been working for the Dental Complaints Service, who are set up and funded by the General Dental Council. And we've been doing compulsory mediation for the last 15 years between patients and dental professionals. Feedback from defence unions is actually very, very positive, and that in the healthcare sector, there's a lot of work going in the optical area. They do compulsory mediation between optometrists and patients, and generally feedback for compulsory mediation is actually very, very positive in the healthcare sector.
Okay, that's great. So,
Michael, Dr. Mark Hoyle.
Dr. Mark Hoyle, good morning, Mark. Another colleague from RTD Chambers, good morning.
I'll unmute him.
Okay. Go ahead, Mark. I say so on Crosstalk.
He hasn't unmuted himself despite the offer.
Can you unmute? Can you unmute him, Martin?
Yeah. Okay. No, I can't. He's got to do it himself. Mark, press your space bar.
Ah, there we are. Hello, Mark. Good morning.
Yes, morning, everyone.
Yeah, go.
Yes.
Go ahead.
Well, I found all of those things very interesting. But what I did also remember, about 20 years ago, there were arbitrations and stuff like that. Many people have also said that. It doesn't seem to have actually gone very much war in a welly in this place. I mean, the trouble is, I think people say, great, it's an idea, absolutely fantastic. And then at some stage, someone wants to stop it and cancel it or something like that. And especially I find in the Middle East, people don't actually want to have that service, because if it's seriously, it's the sheikhs and the others who are just going to see who's going to win or lose. I know that's a simple one, but in the Middle East, certainly, it's a bit of a problem. But I think we just need to get better people, not us, if you see what I mean, but the other people. So if you've got a guy who's got £28 million through, and he says, well, you know, why should we do this, what's it called, you know, arbitration or anything like that? They won't do it. They simply won't do it. And I've got quite a lot of money actually out of it, if you if you want to put it in that way. But they just won't do it. What we need to do is to make sure that they feel that they have a point. I think if that point gets through, I think it will be very good. But Everybody here knows that they've got cases, good cases, etc. But how do the person who really wants to be the arbitrator or the other set of it, how are they going to do it? I think it's very difficult.
Okay, thanks, Martin. Martin, should we put up the first poll question? I was just going to share one other thought. In looking through the report, I noticed what I called a degree of judicial insecurity, and the judges still seem to want to have their fingers in the pie. And my view is that judges should butt out of this. And if they want to be mediators, arbitrators, and adjudicators when they retire, which an increasing number of them want to do to augment their pension, that's what they should do. But otherwise, they should stick to judging in the courts and should not be involved in judge-led mediation, even if it's not on their case. So who's got their hand up now? Let's have a look. Martin, do we have anybody with their hand up?
Not currently.
Oh, here we go. Christopher Martin. Christopher, good morning.
Everybody, I hope you can hear me. I have a problem with my sound sometimes.
You do, yes.
Yeah, I know it's not great. What is the situation currently in Scotland, where the Scottish legislation has made it compulsory to seek mediation as a prior first step before seeking redress from the more conventional court? This has been around for over a year now, and I would certainly agree with Stephen about this, that maybe we should be looking more at the courts in England and Wales, considering more seriously how we can improve this situation. I think the general feeling is that the amount of money which I've seen coming through is generally dealt with in the small claims court jurisdiction. I was wondering if anyone's had any experience of the Scottish
Okay, thanks.
More compulsory.
Thank you, Christopher. Well, do we have anybody who's any experience of what's been going on north of the border? I certainly don't.
I've got 3 raised hands at the moment: Louise Clark, Dr. Kirikow, and Yvette Fidler.
Okay, well, let's take, we've had Louise, we'll come back to, was it Yvette? Good morning, Yvette. Do you want to go ahead? Would you like to unmute? Yeah, good morning.
Yeah, I'm unmuted. Yeah, so I'm interested in it from the point of view of thinking that what makes an effective mediation is motivated people, motivated to resolve it within the mediation. That's what really makes the difference between effective mediation or not. And I'm trying to work out whether it being compulsory helps or hinders with that. So I'm probably more interested in the ideas that they might bring in consequences for engaging with it, either benefits from engaging with it, even if it ends up in court, or consequences for not giving it a go and not, to help improve the motivation. So I can't quite decide yet, but I think there's been some really interesting points made. And I thought Stephen's point about making it compulsory so that people get more experience of it and they get to see what it's like. And once we get them in the room, we can, if we can talk to them, then we can get them to understand how it might benefit them and why they might be motivated to take part in it. But I do slightly dread the idea of people coming in compulsorily and just sitting there, crossing their arms and just going, not doing it, sitting there for an hour. There's also a slight sort of, oh, do we really want that going on?
Okay, thank you, Yvette. Who have we got next? There were some other people with their hands up, Martin.
Yes, Dr. Kirikow.
Yeah, just before we go to him, there is, of course, this almost halfway house of mandatory mediation, which is how construction adjudication works, which actually means that if one party, in this case, wanted to go to mediation, then the other, there was, in other words, the applying party, then the responding party would have to respond and take part. So at least you, Yvette, to your point, you'd have at least one party that would be motivated. Okay, Dr. Kyriakou.
Hello, yes, hi, it's Catherine. Sorry, so
yes.
I just wanted to say a couple of points. One about the judges. I mean, they have all that experience. They are forced to retire at 70. And I just think if you expect mediation to be taken seriously, you need a large number of professional people doing it. And why would you exclude them? I just really don't think that people should be excluded, unless they actually weren't up to it, which obviously is not the case. So that's number one point. So, it's about professionalizing it. It's about having a sort of better view so that the public don't think it's meditation. Although there's nothing wrong with meditation, but it's not in the business sphere, is it really? And just thirdly, about whether compulsory mediation should be brought in. On balance, I can see both sides, I really can, but on balance, because of this professionalism side, I don't think it should be forced, because then you'll have large numbers of people doing it, they won't be scrutinized, they won't, it'll just be an afterthought for them. And I think you sort of get into problems with the reputational side of it. So that's just my view.
Catherine, thank you. Actually, I wasn't suggesting that the judges should be excluded. I was suggesting that they should be excluded while they're sitting as judges. Once they retire,
oh, I see.
That's absolutely no problem at all. Martin, I think we've got Lewis from the Chartered Institute of Arbitrators on, raised his hand.
Yes, certainly. Thank you, Michael. For those who don't know me, my name's Lewis Johnston. I'm Assistant Director for Policy and External Affairs at the Chartered Institute of Arbitrators. I think there's been some really interesting comments made thus far. I did read the report quite carefully, and I do think that this is a moment broadly to be welcomed by mediators. I think we, as the Institute, have been encouraging greater use of mediation and other forms of ADR already. As has been alluded to, there is already a foundation of different forms of ADR, notably adjudication, that are already perhaps mandatory, and then also other ways in which mediation has been introduced into the system and is assumed to be a default. I think it's important, whilst acknowledging some of the caveats and some of the details that sit underneath this, not to lose sight of the fact that this could be a very significant development, and that it's an opportunity to be really to be taken. The points, I think, about perfunctory participation and guaranteeing party autonomy are all very valid, and I think the real crux of the matter here is the detail of how anything would actually be introduced. Although I do think the report was quite compelling on both of these points, particularly on the party autonomy point, where the court-based adjudication will always remain an ultimate last resort for the parties. That's not going to be taken off the table, and no parties are going to be forced into a situation where they have to settle. Again, I think that there are, when we think about sort of compulsory processes, we also have to think about potential imbalances of power, and that people aren't put in a position, one party isn't put in a position where they feel they have no choice but to settle, because there's an inherent imbalance of power. I also think, just to close, it's important. The Chartered Institute is going to be working with the CJC and the government, offering to follow up on some of the recommendations that are made in this report, because we do think they're valuable. I think the emphasis in terms of the benefits of mediation should rest on improving the scope it has for improving access to justice and access to redress, and not so much perhaps on the cost implications. I think there is a risk potentially in the way that this is being presented, that it's a great way of reducing costs and pressures on the courts, all of which I think are valid points, but we don't want to go too far down the idea that this is a bargain way of closing the gaps that have been opened up through funding cuts to the justice system in recent years. I think it has to be seen that mediation is an investment, and it's a useful way of encouraging and improving access to redress. But broadly, I think this is an important development, and I think it should be viewed as such.
Yes, okay, thank you. So I think the observation I'd make, it's only an important development because so little has happened already, which is really Stephen Walker's point. And I agree with you also, I'm sure we all would, about the benefits of mediation in terms of being able to arrive at what I call kind of lateral thinking solutions, which don't just involve people doing or not doing things or paying money. And the critical other point, which is the possible maintaining of relations or restoring relations which have been ruptured. Martin, do you want to put up the next poll question? The first one, the answer, which was, are you in favour of compulsory mediation? The answer is 61% of the people on the call voted yes. So we'll do the next one. So next question. Julian, where are you?
Hi. Yeah, can you hear me? Yeah.
Yeah. Hello, Julian.
Stephen made a good point about marketing. Someone also mentioned the issue of. I was going to raise the point, but people need to be asked, well, why wouldn't you want to do that? Not about, oh, you've got to do it sort of thing. I think mandatory, the word mandatory sends shivers down to people's spines. And the other question I was going to ask, whether anybody knew of any stated cases where both sides have agreed to actually submit information where when they went through the mediation, these are the savings that were made, because even those people who don't want to get emotionally involved and they don't want to know and they get a bit stubborn, even on the money side, that surely must interest them where there could be major savings. So are there any stated cases where there's clear benefits of mediation?
Okay, thanks, Julian. While we think about that, who else has got their hand up, Martin? Have we see some people with hands?
Susan Bloom.
Susan, where are you? Go ahead.
Yeah, hello. I just think, following on from what Stephen said and listening to some of the comments, that there really is a need to make sure that whoever is mediating doesn't just do it, but their professional reputation of mediators is contained by effective training and proven training with any mediator. Secondly, I feel very strongly as a coach as well as a mediator that part of the differentiation between arbitration and mediation is the effectiveness of listening and the communication skills of the mediator, so that clients can reach their own conclusions and outcomes rather than having any kind of adjudication put upon them. So to that end, both those points kind of reflecting, I think, what part of what Stephen was saying. I'm wondering how many people on the call have experienced cultural differences in communication, because there are some cultures where it is far, in my experience, far more considered, it's considered far more normal, quote unquote, to be very expressive about how you feel and what you feel than, for example, in the UK or the US, where there is less encouragement of that professionally.
Okay, thanks, Susan. I think we better be careful about not going down that rabbit hole at the moment, although I think in a way that was the point that Mark Hoyle was making about there are a lot of cultural differences in the what I prefer to call the Gulf Cooperation Council region, and traditionally things have been sorted out by local trusted people, and they effectively act as mediators. I think I see Mark nodding, but actually they won't necessarily be trained and accredited as such. But anyway, I mean, I think that also brings us to the R word, doesn't it? Regulation. The market is very fragmented in this country by comparison with places like Singapore, and in fact our friends from Singapore might like to comment on that. I forget how many bodies are authorized to accredit mediators, but last time I looked it was an awful lot. In many other countries it's one. So who else has got their hand up?
Pam Holm.
Pam, are you there? Go ahead.
Hi there. Yeah, I'm there, and from the voice you might recognise that I'm not Pam Hume at all. I'm actually Isabel Phillips from the Chartered Institute of Arbitrators, but thanks to vagaries of test and trace, I have had to steal a phone, not literally, I promise.
Well, I hope it's going all right. I'm on my last day until midnight, so I can actually go out and have a pint tomorrow night.
Wonderful.
Go ahead,
Wonderful.
Isabel.
So, yeah, so from as Lewis already mentioned, in terms of the position of the Chartered Institute, it's something that I think is a development which we've seen around the world, that where mandatory mediation or compulsory mediation is introduced. There's a couple of things. It is very much how is that implemented that's going to determine what happens. It's not just about that decision, but one of the things that does fairly consistently happen is that it does begin to change the culture and change the uptake in a way that no other measure that I personally know of does. The other point that I think might be of interest to people who are mediating is I was mediating in the Central London County Court back in 2005-06 during the pilot of the automatic referral, which of course wasn't quite the same in the sense that you couldn't be forced to mediate, but it was an opt-out rather than opt-in system. So everybody was referred, and the result was quite interesting in terms of my experience, particularly of the parties and the lawyers, and the difference sometimes between them. So one particularly memorable moment, which just speaks to the concerns of somebody who spoke earlier. It was a mediation that had been, a dispute that had been going on for several years, very typical case, settled on an amicable basis within an hour and a half of the start of the mediation. And because of it being a pilot scheme, it was being tracked and studied as it went. So after the mediation, I was sitting with one of the lawyers while he filled out the questionnaire. And when he'd finished that, I said, so how are you feeling? How do you find it? And he said, oh, well, I mean, mediation's completely ridiculous and it's a complete waste of time. And I said, oh, that's interesting. Sort of tell me more. He told me a little bit more. And I said, and in this situation where you have a settlement in an hour and a half, oh, well, this is the exception. And I just think that's quite an interesting example of, I think that maybe that changed afterwards, but that the fact that even when people are not enjoying the idea or don't even think it's a good idea, that change partly happens because even if he stuck to his position, the parties had a something that they were happy with in a way that they wouldn't have otherwise been. And as that lawyer gets, in a sense, forced into mediation and again, I think that's where that attitude can and might change. And going into mediation where you know that one or other of the parties is quite resistant to the idea or isn't enjoying the idea, I think some of the ideas from the therapy context where seeing somebody as being resistant or anti when you start a mediation will probably make it harder for you as mediator rather than just seeing it as somebody who maybe just needs a little bit more time and an experience, but not setting up that in your head as, oh God, this person doesn't want to be here and it's going to be awful. So just a couple of practical thoughts on it.
Well, thanks, Isabel. And it's an interesting observation, of course, about the Central London County Court scheme, which in my experience worked very well. That's one of the places that I think probably quite a few of us got started with our own flying solo for the first time, and it was a really good introduction. Who have we got? Jonathan, somebody or other. Yeah, Jonathan, you there? Go ahead.
Yes, thank you very much. A couple of points. First of all, I must endorse Stephen Walker's points about marketing. For those of you who know of me, I'm essentially a marketing person. Creating awareness is so important. And I'm not sure when Lewis was talking about costs, I find that cost is a great motivator to individuals and indeed small companies to being able to do something very rapidly. You know, that's what interests them, not necessarily the access which is of interest. One area talking about compulsory mediation, which is what we were talking about, I specialize in special educational needs and disability. Most of my clients are that. And they have the equivalent of a MIAM, and where you have an organisation versus an individual, the local authorities have a duty to mediate if the individual, the parent mostly of the child in question, would like it. And if they don't want it, they need a mediation certificate to say they have heard about it, like a MIAM in the family court and so forth. But also the other element in terms of mediation is the emotional side. And when you're dealing particularly with autism, for example, where it is hereditary, I have seen most times it's come from the parents. And that creates a really, really difficult environment, as well as all the emotion that the parents have vested interest. They also tend to be on the spectrum, not that we call it that anymore, for autism, and therefore it creates a huge challenge. But the local authorities have the compulsion as there to mediate if the person. But if the individual wants to appeal, they have to have their mediation certificate.
Thank you very much, Jonathan. We have Tabitha, and just before that, Martin, can you put the last poll question up, please? Thank you. Tabitha, are you there? Go ahead.
Thank you. Yes, and apologies that my camera isn't working. I'm really interested to know, and I may have missed it, but is there any expectation of a response from either the Law Society or the Bar Council, some of whose members will probably really embrace these recommendations, and some of whom might well see it as a genuine threat to a process that they believe in, and of course potentially a threat to some of their fee income? That's the sort of first question. And my other sort of observation is it realistic for a judicial system that seems to be suffering from a lack of funding to start having judges also being mediators?
Well, thank you very much, Tabitha. You can answer, that's the next poll question. Should judges be involved in mediation? I suppose the subset of that is whilst they're still judges. So you can say yes or no to that one. So sorry, what was your first point? I feel a bit like Boris at a press conference now. What was the first point again?
It was whether or not you're anticipating any response from either the Bar Council or the Law Society in terms of whether or not their membership will agree with these recommendations, or whether they will feel it is a step too far to make it more compulsory.
Well, I think the answer to that, others may know better than me, but I think the answer is that responses are invited, but I forget quite how that works. But I mean, to pick up a point that was made right at the beginning, I think there's quite a lot of vested interests who possibly don't like some of this stuff. And we've heard a bit about that. And so I'm not sure that this is going to be welcomed with unbridled enthusiasm by everybody concerned, but there we are. Okay, Martin, who else we got with their hands up?
Jeff Lewis.
Jeff, are you there?
Yeah, yes, just to...
Good morning.
Yes, I am. Good morning, everybody.
Welcome.
Thank you. Just to respond to Tabitha's question about the Law Society, I may be able to assist on this one because I'm on the Civil Justice Committee of the Law Society, and I can tell you that this paper is very much on our radar. I mean, it hasn't been discussed yet. It will be discussed at the next meeting, but there are a number of mediators, including me, on the Civil Justice Committee. And obviously there are a significant number of mediators within the profession generally. So I don't think it, without wanting to preempt what people are going to say, I don't think that it is likely that there will be opposition to what is proposed, certainly not on the grounds of people protecting their own income. And I think the other point to make from a practitioner's point of view, as well as a mediator's point of view, is that I don't necessarily see there being a tension between life in practice as a solicitor or a barrister and the concept of mediation. Mediations are good for lawyers because, first of all, it enables you to get close to the clients, and secondly, it avoids that horrible situation where you come out of court having lost and the client says, why on earth didn't we settle? So I don't necessarily see a tension between life as a solicitor and barrister and the concept of mediation.
Okay, well, thanks, Jeff. Well, I entirely agree with you. I think that happy clients tend to be people who come back. And if things are resolved with perhaps a shared degree of unhappiness between the two or more sides, then generally after they've slept on it, they would think, oh goodness, thank God that's over. Okay, I think Roger Levitt, I think Roger, you had your hand up, go ahead.
Yeah, thanks, Michael.
Good morning, welcome.
Great to be here on this sunny day.
Well, it started off a bit slowly, but we've got going, haven't we? I think Stephen gave us a bit of an injection of energy there, which was great.
Yeah, my view is that I don't see any tension between the compulsory element and what we actually have at the moment, because I think that since the CJC report in 2017, where the CMC supported automatic referral to mediation, I think we've moved further in the direction of compulsory mediation in practice anyway. I think most cases I'm seeing at the moment are either people mediating before they issue because they're not convinced that it's actually a good use of their time to litigate at all, quite apart from whether they could get heard by a court because of the pandemic, or cases where proceedings have been issued and the court has given a stay and directed the parties to go away and mediate. So I would argue that we're actually there anyway. It just hasn't been given a label.
Yeah, that's an interesting point, isn't it? It's a kind of, in a way, I describe it as a kind of curiously British fudge, where we sort of got there by a very roundabout means. Maybe we just need to be clear about what is actually happening right now.
Michael, Russell
yeah.
Shackleton to speak.
Sorry, who wants to?
Russell Shackleton.
Russell, are you there? Go ahead.
I am. Hopefully my connection will stay solid for us. From what's been said earlier, there's a number of points that I do agree upon. I think one of them around, I think we've got some structural questions to look at within the mediation profession, and I think the number of or quality of the training providers needs to be something that we need to look at to make sure that we have all got the right level of training. And also things like the dispute process, where we have a process for resolving disputes, but whether or not that needs to be something which is much more where by perhaps a CMC, mediations are filed there, and that's given a bit more of a boost so that people can see that the profession has actually got more independence and objectivity into it that may come into it. And the other area, I think, in life, you don't get anything, you very rarely get good things cheap. And I think one of the...
Oh, we're losing you, Russell.
To manage mediation. I think one of them is around the courts being clogged up. And I think we need to genuinely look at the position with smaller claims and how they are resolved and cleared in a way. And I think perhaps that to encourage some of those to be cleared through to make space in it, there could be arguments for some kind of levy which the courts can sort of give to provide to mediators to actually make that piece something which is more professional and dealt with, and maybe eases a lot of the pressure elsewhere in the court system.
Okay, thanks, Russell. Peter Colby. Peter, are you there? Go ahead.
I am. Thank you, Michael.
Hello.
I wanted to give a workplace context on this discussion. It's a really great debate, and I just wanted to give a real life example of where we have actually put mediation in a inverted commas compulsory manner. And I'm always talking to organisations about changing from grievance procedures to issue resolution procedures. It's a subtle change, but it's how you approach things. And an organisation I was in, and I'm talking 15 to 20 years ago, that had on average 12 formal grievances per week. They were just in it, and the trade unions played a real part in that as regards formal processes. We took that organisation to one formal grievance in 15 months. And the way that we did that was to make mediation compulsory in a way, but it was our issue resolution procedure that tried mediation first. And then if mediation didn't work, it then went to a formal process, and then it went to a tribunal should it be required. And by, you know, a few people have mentioned the training. It's so important that you get the right people to be able to mediate these disputes. And by doing that, and it wasn't just HR people in organizations, it was line managers as well, and giving them those mediation skills just to sit down with people and understand their issues and help them to resolve those issues themselves worked 99.9% of the time. And it was only one, you know, in 15 months, one thing went to a formal grievance. And that lasted 20 minutes because it was one of these people that just had no sense of rationale. But all of the other issues were resolved, and it was just through talking to people. So although we didn't say it is compulsory, we built it into our processes in an issue resolution type of methodology. And when you then get the right people mediating the disputes, you then just get a complete cultural transformation. So
Okay.
I just wanted to make that point from a workplace perspective as well.
Okay. And I think, Martin, we have the result that 80% of people, what was the result of the poll number 3, Martin?
80% of those who voted against judges' involvement.
Okay, so I'm not a complete lunatic. I'm pleased to find that out. Okay. Anthony Fincham, I think you had your hand up again. Go ahead. Anthony, you were there?
Put it up by mistake, actually, Michael. I've now taken it down.
Oh, that's all right. Now we had some, who else did we have?
Christen would like to come back.
Oh, Christen, yeah. Christen, just bear with me a sec. And then Alvin, who's been very patient from Singapore. I was just going to ask you if you wanted to make an observation just after Christen, if that's okay. I don't want to put you on the spot. If you don't want to, that's fine too. Christen, go ahead.
Yeah, well, thank you. I just really wanted to come in on the end of what Pete was just highlighting, which is, as I said, my own experience is kind of new, moving from the kind of the development, almost psychological development of people. But I recognize in what I'm starting to do that a big chunk of the mediation, very often in the unbalanced situations, is allowing a voice to be heard and articulated more than it is about the resolution, or at least in part. And which kind of highlights to me that probably even within the forum as we've gathered here today, there's quite a broad spectrum of places where mediation is being used. And actually it probably wouldn't hurt in terms of the marketing if we could come up with some sort of ways at almost being able to in an instant articulate a style of mediation, whether it is kind of resolution, kind of it's sort of and more legal in nature, or whether it's more kind of that place of giving a voice where there is a grievance and that element is often less focused on what's the solution, there's actually what's the process, and has the process therefore resolved something in me. So I just wanted to endorse really the way Pete was kind of presenting that.
Okay. Alvin, in Singapore, do you want to just very briefly introduce yourself?
Thank you, Michael.
See me.
And hi, thank you, Michael and Martin, for allowing me to listen into this very interesting conversation. Hi, everyone. My name is Alvin Sim. I've just taken over as the next executive director of the Singapore Institute. Yeah, CIMI, that's right. Yeah, Singapore International Mediation Institute. And our role as an organization is to set and manage certain standards for mediators. We're about 6 years old, and our journey is still quite 6 years is not a very long time, although we are quite novel as an organization. We don't have any other organizations either in Singapore in our part of the world. So we're hoping to do good work in that area to improve mediation standards and also to sell the mediation message. The conversations I've heard this morning are very interesting and enlightening. And just perhaps by way of comparison, Singapore's mediation journey started when I was a rookie lawyer about like 20 odd years ago. I recall that as a rookie lawyer, I was involved in one of the first few mediations in our High Court. At that time, there was an initiative to make mediation effectively compulsory. So the judges themselves also doubled up as mediators. So we had a kind of litigation process where mediation would be attempted by the High Court judges, and depending on the outcome, if it were not successful, the judges will continue hearing the cases. If it was successful, they would record a settlement agreement then. The state courts, which is the equivalent of our your county courts, the family court also, had a similar system, which I believe, I understand still exists today. The state court judges would actually be mediators. It's a compulsory process, I understand, and all cases would undergo mediation. For good reason, because at that time we had a backlog of cases all round in the state courts as well as the High Court. This was one tool to not only make cases less litigious, but also turn over the cases faster. I think my experience then was that, and this addresses the questions that we've been talking about this morning. I think for mediation to be made compulsory, I think there were mixed results. So I, in my limited experience, remember running a lot to the state courts, handling cases at the magistrate level, at the district judge level, and the district court level. I think some clients did feel that it was a kind of forced process. And I came away with the conclusion that some cases would indeed be very suitable for mediation, some others perhaps not. And it partly depended on the attitude of the client involved. Of course, attitude, I think, is also informed by what the lawyer tells the client, and the education process is very important. And I think in Singapore, likewise, we're still on this education journey. I believe some people have no idea what mediation is or what it seeks to achieve. I've since moved on to do in-house counsel work in the government, and I've gone through legislative work in public administration, and I just completed a stint with our Trade and Industry Ministry, where I was able to hear about consumer complaints. Consumer protection issues is one of the subject matters of our Trade and Industry Ministry. And I understand that when we try to introduce the idea of mediation to consumers, because it's really not worthwhile for consumers to, spend so much money on lawyers going to court and all that. Some of them still have the idea that, mediation will help them win, when, as I think some of us have said, right, it's really about fair resolution, not about having an outcome, a binary sort of outcome, whether you win or lose. So I think with regards to making mediation compulsory, we need to be a bit circumspect. I think we need to sort of inbuild it into the process, which I think is the case in Singapore. I don't think the High Court, I haven't heard at least, that mediation is really compulsory, really pushed. I've got to check the latest practice directions. Certainly it still is in the state courts, I think, but certainly it's quieter. And I think we're still in a position where we're trying to see how parties can be nudged to seriously consider mediation and make it, a part of the mainstream, so to speak, in terms of ADR, and even as part of the court process. So okay. Those were my thoughts. Thank you very much, Michael.
Okay, well, thank you so much. Do we have anybody else? We've just got to about 11:10, and I think I was going to ask Dave in a minute to just say something about the next meeting, but maybe we just got time for one more observation. Anybody else want to have a go? Who have we got with their hands up, Martin? If any.
Julian Whiting wished to say something?
Yeah, go on, Julian.
Yeah, I was just thinking back to the judges. Some people made some good points. I think there's obviously some very learned people with lots of experience, but I think the whole system, the legal system, a lot of people come to the system for the first time, adversarial courts, judges and all that. There needs to be a whole wash through of how the system has operated, this Dickensian sort of situation, which people quite understandably run away from. So the whole thing needs to be transformed. I don't think judges shouldn't be involved, but I think they need to perhaps set aside what has hitherto been the way it is. And I just think mediation probably at one point was regarded as Guardian reading, sort of green issue sort of thing, but I think it's wonderful. And it's great that you guys are doing it. And, you know, I think it's good for everybody. So I just wanted to throw that in.
Okay, thank you. Well, now, Dave, do you want to maybe just say something by way of kind of parish notices for our next meeting and also a possible social gathering later on in the year? Over to you, Dave. Then what we'll do is we'll end the formal session, but we'll leave the meeting open, Martin, if that's okay for a while. People can just chat. Over to you, Dave.
Thanks, Michael. About this point about judges mediating, I know I'm a very good friend with a mediator who lives in Dublin, and they ran a mediation course over there, and they had, I think, 8 judges on it, and they failed every single one of them because they just couldn't switch mentality. But that's a bit by the by. The next meeting is going to be Wednesday, the 15th of September. And I'll send a save the date email around to everybody soon on that. And in relation to a social, we were thinking of having a lunch coming up to December or in December, possibly at the Savile Club in central London. So I'll send a date for that a bit nearer the time.
Okay, Dave, that might be the inaugural meeting of the Mediators' New Breakfast Club Dining Society.
Yes, we'll have to think of a good acronym for it.
Maybe that's not a very catchy title. Okay, well, thank you, everybody, and thank you for your contributions. Thank you for attending. I think we had a maximum of 50 or so people on the call, and we look forward to seeing you all again next time.